That concludes our action agenda, and that brings us to our discussion agenda, item number 21, which is an update on the Derrick Pond Road property. And we welcome Mr. Michael Montgomery to the podium to lead us through this discussion.
Mr. Gant, if I may, before
Yes.
Mr. Montgomery gets started, I'd like to provide a little bit of context, although Mr. Montgomery is going to include this. At the December board meeting, there was a request by the board which was supported of interest for us to have this conversation. We felt it was important to include, of course, legal counsel because we have had attorneys involved with this purchase of property. It was a great opportunity for me to get up to speed because this was not an area that was under my supervision at the time. So we used some calibration of various legal counsel, but Mr. Montgomery was the ideal candidate because he was not involved at the time, so there's a sense of neutrality here that he can report information to the board and to the community to make sure that we have information out that would help assist his conversation as we move forward and to make sure that our community has the information as well as our board. Mr. Montgomery, welcome. We're glad to have you here this evening.
Thank you, Dr. Melton, Mr. Chairman, members of the board. For those of you who don't know me, I'm Mike Montgomery. It's my privilege to be one of the lawyers that gets to work with Richland Election 5 from time to time on different matters. I was going to put this more on Dr. Melton because she's the new superintendent, and there's been a lot of talk about Derrick Pond property and what's the story on that and what can we use it for and why haven't we built a school there. Some of those questions I can't answer because they deal with decisions that people made that I can't get behind what they decided. But what I can do is what Dr. Melton asked me to do is sort of brief y'all on the facts so that everybody's operating on hopefully the same plane of information. And so what we have done is taken the opportunity to try to address four basic areas: the history of the property acquisition, any issues that might be out there that we need to deal with, and what information the board and the superintendent and administration need moving forward as it relates to those property. And so what we have done in that regard is we've reviewed the files that the district has in relating to the property. We've talked to the people that were involved, both professionals that were hired by the district and some of the district employees who were involved in that process, including the superintendent at that time, Dr. Berg, Mr. Price, who was the chief financial officer at that time, Mr. McAllister, who was the director of projects under the bond referendum where this started out. There were also some questions involving some Richland County ordinances and land use rules. We've examined those. We've talked to the due diligence professionals that were involved, the engineers, the architects, the lawyers, and we've also reviewed the board minutes and the board packet information relating to this property going back to 2009. So just from a basic background standpoint, the school district has a policy with regard to land acquisition. And part of that policy, or one tenet of that policy is that it says that a school board should be looking to have land in inventory to use in the future. So you always have that parameter out there as you start. This is the tract that we're looking at. It's a 47.39 acre tract, and when it was originally contracted for, it was parcels B, C, D, and E. And so as we go through, you'll see that there are 4 parcels. It has a little bit of frontage on Mount Vernon Church Road, and it also has Derrick Pond Road, hence the name of the site and how it's been called, has substantial frontage on Derrick Pond Road. Interestingly, and this is just a picture of the aerial, the district had looked at another piece of property on another location and actually had a contract on that property that it did not approve and didn't go through before this property became available. The property was actually initially on sale, and we'll see some of the documentation. The asking price on the initial property purchase was $830,000. After the board gave permission on April 12th, 2010, the district entered a contract to purchase that property. Dr. Berg signed the contract. It was for 47.42 acres pending due diligence. There's some minutes on April 12th where the board approved a property matter out of executive session. That appears to be the board's authorization for the superintendent to sign the contract. District was represented by real estate agent Pendleton Grove, who was with Colliers Keenan at the time. The contract was a pretty standard purchase contract. It afforded the district a 120-day due diligence period, which is an opportunity to do all your inspections, to do the things that you wanted to do under your board policy, and otherwise to determine the suitability of the property. This is just the minutes from April 12th, 2010. You can see the motion actually made by Ms. Hutchinson, seconded by Ms. Hammond, to approve the administration move forward on the contractual matter. Then we go through, here's just a copy of the contract. You can see that Dr. Berg signed it, and you can see that it was for this 47.42 acres. You went through a due diligence period. A number of things took place during that 120 days. You had surveys, a boundary survey. You had the title work and the title examined by the law firm that was handling the transaction. There was a Phase 1 environmental study. There was a wetland delineation and verification with the Army Corps of Engineers. You had a traffic engineering study. You had a geotechnical study, survey and report. One of the issues on that property was that the sewer was not there. So you had to do a study, and you had to obtain some easements and some agreements to purchase some easements so that you could take the sewer from the school, and in fact, you acquired easements across adjoining property and a right-of-way through the Department of Transportation to actually bore under Interstate 26 to attach to the sewer that's on the other side of Interstate 26. There's also some appraisal reports. You had a number of things done from a due diligence standpoint. They're reflected in this memorandum. Again, you see just a picture of the property there. You also had to get approval from the South Carolina Department of Education. The South Carolina Department of Education in August approved the site as an appropriate site for a school. This is where the Army Corps of Engineers gave you approval on the wetlands delineation. One of the things you've talked about, and we've talked about it, I know, Ms. Hammond is particularly always interested in it. We've talked about site adapting schools. And so one of the things that you looked at that time was site adapting Oak Point Elementary School. And the architects and the engineers did some preliminary design on that site. This is just a copy of a map that shows a site adaptation of that school on the site. There were some site plans done in the upper right-hand corner, which I'm not laser printing. In the upper right-hand corner, you'll see the survey of the property. We'll talk about a couple of issues that arose. One of them, which is a piece called Parcel E, which had some interesting things. And also, we'll talk about some issues with regard to a Richland County ordinance and zoning there. So this is the survey and the plat that was done, and it shows the property that the district acquired ultimately and that you still own. And again, that property shows the frontage on Mount Vernon Church Road and then the Derrick's Pond Road site. Now, Mount Vernon Church Road is a state highway. Derrick Pond Road, interestingly enough, was previously a state highway. But apparently in 1991, the state abandoned that highway and returned it to county maintenance. And one of the interesting things that came up in due diligence was that no one knew how wide the right-of-way or what the ownership was. And in fact, the county and the district's attorneys worked to try to locate what the right-of-way was for that road. And from the documents that I've reviewed, no one ever came to an actual conclusion as to what that right-of-way was on Derrick Pond and whether it was actually a deeded right-of-way or it was not. And as you go towards your future uses, that has a role in what can be done and how you might develop that property. You also, and this is one of the maps here that shows the sewer easements. You have the sewer easement and you see where it goes under the 200-foot right-of-way at Interstate 26 to attach to the Richland County sewer main that's on the other side. And that was one of the site development costs that you addressed and dealt with during due diligence. You actually acquired those easements. They were purchased, and the district owns those easements. So the district maintains the right to connect to the Richland County sewer on the other side of I-26 there along that path. This is just sort of a timeline. I'm trying to, Dr. Melton wanted the information, but she wanted it quickly, so I'm trying to not burden you with a lot of time. But just from the standpoint of what happened, your initial contract was for $582,750, which is a price of $12,500 an acre for this 47.42 acres. OSF approved the site on August 27th. You had a closing scheduled for early October, and the closing actually took place, but the disbursement did not take place until Richland County approved the plat, and the plat was recorded. So the closing for parcels B, C, and D took place on October 14th. The board voted to approve that shortly before that time. And that actually, officially, those deeds were recorded on the 18th after the plat was recorded. One of the things that happened is that during the title search, there's a part called Parcel E, which is a 2.67 acre part of this. It's a little triangle that you saw, and we'll see again. And that little triangle has a question of the title, and it didn't have to be, wasn't really a question of title, but there was a description issue, because in the chain of title, there was a map that was relied on that wasn't a survey. And the map dimensions didn't quite match, such that when the survey was done, it didn't close. And it gave the council that was representing the district question as to whether the adjoining property owners might have some interest in that property. And so obviously the district didn't want to close on a tract of land without title insurance, and to be insured they had insurable title. So right before that closing, the district entered into an addendum with those property owners where a portion of the property, this was 2.7 acres, so about $33,000 of the purchase price was held, and the contract was amended. That amended contract afforded the district the option to walk away from that parcel, or for those folks to have what's called an action to quiet title, which means they would file an action to clear the title up with the adjoining landowner. They also had an option to seek condemnation. And when I say they had an option to seek condemnation, and we'll look at the minutes in a minute, but the sellers actually wrote the district letters and said, we would like you to condemn this property to help clear the title. Now, I won't venture too much into their motivation there, but obviously, if a public entity exercises the right of eminent domain, which is called condemnation, one of the advantages to that from a legal standpoint is that it goes first on any court docket. So it can happen quickly. If those owners have to file a quiet title action, they go in the regular order on the court docket. So it may take 2 or 3 years, and you're looking, as we look at those site plans, you really need that triangle to look at your design. Ultimately, none of that happened, even though on December 13th, 2010, the board approved their request to move forward with condemnation action, because the lawyers and the folks worked out an arrangement where the parties that potentially had an interest in the property deeded the property over. So the district for that 2.67 acres actually has 6 deeds deeding it in from all the people that could have had a potential interest. And they worked out their settlement proceeds to do that. So you acquired District E, or Parcel E, in that way. Just going through some of the documents.
Mr. Montgomery, would you go back to that last slide just 1 second?
Yes, sir.
And I hesitate to even, I know that this is just a typo, but you've got actually that 4th bullet coming down has October 14th, 2018, and then October 18th, 2018. I'm sure that probably should be 2010.
Those are both should be 2010.
Okay. Second thing I want to ask you, do you need a bottle of water?
No, sir, I'm
Okay,
great.
you're okay. All right. Thank
All
you
right.
very much.
Okay. So August 9th, Dr. Berg, and this just sort of goes in, Dr. Berg received a message from Mr. McAllister. The administration recommends to purchase the parcel of land identified for the price of $582,750. August 9th, the same day, there are 5 by 5-0 vote. The board approves that purchase. Interestingly, Mr. Gant and Ms. Hammond were both on the board then. Both of them were absent that evening, but the other 5 board members voted to approve that purchase. So we've already talked about, and I'll go through, the actual closing on Parcel E was actually March 21st, 2011. And just for information, one of the things that Dr. Melton asked me to do is look at other things that were unusual in cost. In order to get that Parcel E issue resolved, the district spent $6,760.20 on additional fees and cost. This is just the internet map of Parcel E. These are the letters, just for the record, that reflect the request by Mr. Graham and Ms. Crooks that the district entertain condemnation of the property. So, there was some talk that I've heard about the district aggressively trying to pursue this, and one of the things that the record reflects is that this was something that these property owners requested and asked the district to do. So it was not an unfriendly act. It was an act designed, I think, to expedite the closing for everyone. And that was actually approved by the board on a 4-2 vote on December 13th, 2010. So just that there. Now, we had another issue that came up, and this really came up after the closing, while the planning was going on, and after the plat was approved. An issue came up with regard to, as I told you, there was some question always with result to the status of Derrick Pond Road. And county staff determined that there was an issue with regard to an ordinance in the county that requires in rural and a couple of other zoning areas that a school can be built, and there are 4 specific requirements. One of the requirements to build a school in that zoning area is that it be on a collector or thoroughfare road. So it can't be on a what they determine is not a collector or thoroughfare road. And the county and the district's representatives had a number of meetings, it appears, about that issue. And there was a real question as to how to address that, because the county was not able to identify the exact right-of-way, which made a difference, as we'll talk about in a minute. And there was also a land swap agreement that we'll talk about that would have afforded the district access from Mount Vernon Church Road, which would have made this an academic question. And so those 2 issues came out. There were a number of plans between the designers, the engineers, and the other folks working for the district that time to enable you to address this issue. One of the mysteries that I don't have an answer for is that there were a lot of things that were left hanging in the air, and I think, again, this is not from the records I've reviewed, but it appears that there were some decisions made both by the board and the administration maybe to pursue other things for the benefit of the district as opposed to building the school on that site at that time. On January 5th, 2011, the Development Review Team, which is the staff of the county, issued a letter saying that the proposed school does not meet the special requirements of Section 2615B. It was 64 then. The county's amended the ordinance several times since then. It's now 67, but is the special requirement the school does not have primary access from a thoroughfare road or a collector road. So that was a basis for their denial. A number of things happened there, and just from a background standpoint, on December 30th, 2010, the district learned that DOT had determined that Derrick Pond Road was removed from the state highway system February 19th, 81. We got the notice that DRT had denied the district the plans because of the road was not from a thoroughfare. The designers then created 4 different options to solve the problem. Option A was the land swap we'll talk about. There were other options, including appeal, which was actually pursued but never completed, an application for rezoning. The property can be rezoned, and also there was an option to relocate Derrick Pond Road. So there were several options out there that were available to the district. On February 2nd, 2011, Mr. McAllister signed appeal documents to appeal the DRT decision to the Board of Zoning Appeals. And just so everybody understands that process, if you don't, basically what happens, and I guess I can speak to this from some firsthand knowledge, the manner in which zoning happens in Richland County is the Development Review Team is the staff, and they make a recommendation. That recommendation ultimately has to be approved by the Board of Zoning Administration, and it can be appealed. And then it can also be appealed to County Council. So there are several steps that one can go through to address that review. In this case, what we'll see is that the appeal was started in June of 2011. The superintendent directed that they not pursue the appeal. They asked the county to hold it in abeyance until they were ready to move forward. I can't find any indication that there was ever any moving forward beyond that point. Just to go through there, now we get to the issue of the land swap. And what I can tell you is in September of 2010, there was a contract made with the adjoining owners that we'll look at in just a minute, the Derricks, ironically, on Derrick Pond Road. And Mr. and Ms. Derrick agreed to swap some land, which would afford the district some frontage on the road, which would afford them the opportunity to basically build the drive and the access to the school from that thoroughfare. There were some discussions with Mr. Price and the District 5 attorney and engineer went out there and talked about him. A few days later, Mr. Price reported that Mr. Derrick called him and advised him they didn't want to do the land swap as agreed. He asserted, according to Mr. Price, that he felt that the access road to the school would devalue the property. About a month later, Dr. Hefner received a phone call from Mr. Derrick's son, who, according to Dr. Hefner, said that the Derricks felt like they were bullied by the district's attorney and Mr. Price to sign the document, that they will fight every effort to build the school, and asked the district not to have any more contact with his parents. There was later a letter that was mailed to Dr. Hefner, which said basically those same things, and they were purporting to, quote, withdraw their offer. I would say from a legal standpoint, they had a contract, not an offer. It wasn't subject to withdrawal, and the district certainly had the opportunity at that point, had they chosen to take action from a legal standpoint to enforce that contract. Just so as I go on, the Board of Zoning Appeal was canceled a couple of times. The district attorney reported that in May, Mr. McAllister asked him to ask the hearing be continued until further notice. And according to that attorney, there was no hearing took place, and they were unaware that any action was taken to try to enforce the contract with the Derricks. This is the contract. It's a very simple contract, but it agreed to swap, and the plat attached to it showed the land that was to be swapped. And you can see the triangle at the top there that addresses the access issue from Mount Vernon Church Road. And this is just a blow up of that plat. And as you can see, what the district was going to do is essentially take 3,000 square feet and give 13,000 square feet to cause this to happen. And then, so from that point, what we know is that there were a number of legal and other options that the district perhaps had to enforce those rights. There are also a number of options that could be pursued to utilize that site, could have been pursued at that time. I am informed that at that time a decision was made, at least administratively, to move the funds that were going to be used for that elementary school due to some changes in enrollment projections and other things, to move those funds into Dutch Fork High School and Irmo High School projects, and that's what those funds were used for, and that the elementary school was put on hold at that point. So then there's one other item that came up in the minutes. On April the 25th, 2011, there was a motion that was passed 6-0 with an abstain to authorize the chairman to seat a committee to work with legal counsel to investigate reported misrepresentations with regard to the 2.67 acres, and also to investigate the circumstances surrounding the breach of contract by the Derricks on the land swap. I haven't found anyone that knows that that committee was appointed or ever reported. So there were three things there that sort of just hung and seemed to have not been pursued. So, you know, when we look at this, we always look, what are our options moving forward? And I think the district has several. If you were to choose at some point to construct a school on that property, you have some options with regard to your planning and also with regard to how you address location that you could do. You could also look at a rezoning of that property, which might be a possibility. You could also look at, there's some rights of way and other pieces of property adjoining that you may have some access to use for a school. You also, I think, would have an option to sell that property. I think that it is, and I don't purport to be in the real estate business, nor do I purport to be an appraiser, but just looking at some of the listings of acreage in that area, I think that you would find that property in that area sells for considerably more than $12,500 an acre now. So the district has the option to make itself whole, to look at developing that in the future for a school site or for another site. And hopefully I'll answer any questions, but I've tried to give you the breeze through. I don't think I've made it in the 10-minute allowance I had. Thank goodness Dr. Harris wasn't keeping time.
Thank you, Mr. Montgomery. Any questions? Ms. Hutchison?
Yes, I have two. I know it's hard to keep track of or type dates when you're thinking of one date, but I noticed on the slide several, it was toward the beginning when you were given dates. you mentioned, and I want to give Ms. Hammond credit for being at the meeting, that December 13th, 2010, she wasn't at the meeting. And then on a later slide, you showed a chart of the minutes of the meeting, and she was there. And so to give you credit for, do you know which one I'm talking about?
I had my notes. I know I voted for on the date for the property, and I thought it was an abstention on the eminent domain, if I'm right, and then a no on the site adaptation till I knew we could build on the property.
Well, I was just saying that, just to correct that, for the, that you were there, because I think it had a parentheses that Ms. Hammond was not
Had
there.
Mr. Gann and me absent from one of them at the same time.
You know what I'm talking
You had us
about?
both
I
absent.
thought I was right on the minutes
Well,
there, but
I'm not saying you're wrong. I can't remember that far back about absent on one. I know
Yeah.
my votes on those three, but at that date.
No. Let's see, it wasn't,
on August
it was
9th,
the list, it was the list where you had, maybe go forward on that?
Where you had in parentheses? Was it the parentheses?
In the
one?
parentheses, it was the one with the parentheses. Oh,
There it
back.
was.
that's the
December
December 13th meeting.
Yeah, December 13th, 2010, and I believe then later you showed that.
Okay, did I pick up, I did that one other time, I picked up an abstention as a being absent.
That's right, and that would be an extension.
The
That was
AB
correct.
The AB fooled me, I think, I
That's okay.
apologize for that.
It is confusing. It is confusing. Just to correct, I don't know if we're going to be posting this or what, but just I think, to clarify and all
I think Ms. Stowers
transparent.
can make sure we get that corrected before it goes up.
And for all transparency. And then the last thing is, do we know why the Derricks changed their mind? Because they had signed a contract saying they wanted to move forward with it. And then it was kind of an about face.
Well, and Ms. Hutchinson, we don't know, because obviously we don't know the Derricks' minds, and the Derricks never described to anybody that reported to me why they changed their minds. I can only tell you from the April 2011 motion to appoint a committee, there was some assertion that there was some influence on the Derricks working against the district that caused them to change their minds. That's what I gleaned from the April minutes. But again, that investigation that there was a committee to be appointed for never took place, so there was never any result.
So it seemed to imply that there was outside influence. It wasn't anyone from the.
I don't know that there
It was-
was influence. I don't know who the influence was or what the influence was. Ms. Hutchinson, all I can tell you is from that motion on April of 2013, or 2011, boy, you get me these years,
I know.
shows I'm getting too old. But when you look at that April 25th, 2011, there were two issues. One, a claim of misrepresentation, and another, a question about someone trying to induce the breach of the contract to swap the property. And of course, understand, the district would have had the opportunity had they chosen at that point in time to move to enforce that contract. And apparently that did not occur.
Okay, thank you.
Ms. Hammond and Mr. Lovelace.
You might have been
Mr.
before
White may have
me.
been before me.
You were before me. but Which one?
Then I'm raising my hand after them.
Yeah.
Why don't we just start the far end?
Okay.
Come far end, Ms. Hammond, right back to Mr. White.
I do think it was first.
Is there a statute of limitations on the ability to sue for specific performance under that?
Yes, sir.
There is?
Yes,
Have we
sir.
gone by that statute of
Yes, sir.
limitation?
And that would have, generally in South Carolina, virtually everything, if the contract had been under seal, we'd have had a longer statute of limitation. The contract was not under seal. And just for the lay purpose, under seal is when you see a contract and has LS by it.
Yeah.
And people think, well, that doesn't mean anything. Well, what it means is it's done under seal, and the law imposes a different responsibility on a contract entered under seal. Generally, that puts a 20-year statute of limitations on something, but the general statute of limitations is 3 years. And that would be, I think, what we'd be governed by in this circumstance.
All right, is it then, I mean, I don't know if this is proper for you to comment on this, but in your opinion, everybody's got an opinion here, but is it your opinion that this property could be used for a school if we were able to get more frontage onto Mount Vernon Church Road somehow?
Well, Mr. Lovelace, I think legally the answer to that question would be, I think that it could have been used for a school then,
Yeah.
had some things taken place. Obviously, whether it's used for a school becomes a decision that's practical based on a lot of factors that I'm not privy to answer to, and it's also a political
Well, I
decision.
understand that, but I'm saying, you know, from an examiner of title, or you probably had that done with your description here. I mean, there's a lot of,
I
this is a
reviewed
very
the title work that
complicated
was
situation.
done. Yes, sir.
Yeah.
And understand that, you know, this issue arose from a special condition in the zoning. So if you rezone the property, you could do it as it is, depending if it's rezoned, for example, business-like commercial as opposed to rural, it could be done without that requirement, without that special requirement. Likewise, there are probably some legal things that could be done as it relates to Derrick Pond Road, and there's also the access question. So there are a number of questions that could be asked to make it usable, and obviously then you'd have the question of, do you want to use it for that purpose?
Could we
Is that its highest and best use at this point?
Right. Could we assert that, you know, that we had right-of-way by prescription on Derrick Pond Road, and therefore, you know, that not only belongs to the other people that live there, but also us, since we are property?
I don't think we need right-of-way by prescription on Derrick Pond Road, because Derrick Pond Road, at least as the only way Richland County was able to deny the zoning was by their assertion that Derrick Pond Road was a public road rather than a private road.
It's not a driveway then?
Correct.
Okay.
If it were a driveway, we'd be dealing with coming off Mount Vernon Church Road anyway, and that was, I think, the premise of the land swap, was to create a driveway off Mount Vernon Church Road, which
I got you. So
got
the
you out
people
of
didn't
it.
want a driveway, and so they wanted it to be whatever it is. It's really not, it's just a county-owned easement, I guess, right now.
Well, you know, again, I have not seen any records that support exactly how much right-of-way there is there. Obviously, I believe that there was some right-of-way because there was a Department of Transportation, a DOT state road at one point before 1991. But the way the records are kept from that time, the scope of my engagement for this did not have me going back and looking at what the highway right-of-way was in 1991.
Yeah, I agree. I understand. I'm just trying to figure out what's the best path forward, that's all, you know.
Well, I mean, like, you know, you have an asset, you have a site, you can use it in the future. You certainly have an asset I think you could sell and realize some benefit to the district and the taxpayers. So you have, you know, you're fortunate as a district in that it was a good property purchase for whatever basis that you have, and having that good property purchase is an asset that you can use for a number of purposes depending on how you choose to proceed.
Okay.
Ms. Hammond?
So my frustration was with the 2008 bond. We knew we needed a school site, and we knew that was the area of growth because of the crowding at Lake Murray. What I'd like to just learn from the history, you know, you can't change something that's already happened, but you would say from your presentation, the due diligence was done by the board or those representing us, whether it be attorney or whatever, and the person that they breached the contract. So is that what you're saying?
Well, you have a couple things, Ms. Hammond, and, you know, hindsight's always 20/20.
Yeah, and I admit that, but
And so, I mean, you know, there are a couple questions I would have, and again, I'm looking at it from a hindsight standpoint. You know, from a hindsight standpoint, you know, I would say, well, we closed and we didn't have all the parcels. I'm not sure why we did that. I suspect there was some discussion about that at the time, but I wasn't privy to that. And also, you know, there was a lot of, as I understand it, again, I wasn't privy to it, but as I understand, there was a lot of political angst going on. There was apparently some opposition to locating a school there from some folks. So there's a lot of things going on there. But, you know, I think that from what I can see, policy was followed, and the district made a decision. And, you know, you can go back in retrospect and say, was the right decision made? And again, it's hard to look at it from a hindsight standpoint. But obviously, there was a decision made. The purchase was properly authorized. You know, the board vote to do that was unanimous of the people that were there. So, you know, I have to feel like that the proper process was followed. There was a little surprise, you know, and where you go on how the engineering took place, where you go on some of those other things. You know, I think part of the answer to the question is there was a decision made not to proceed with some of these issues, and had you proceeded, you might have a school there today.
well, and I think it's important, and I appreciate your presentation, because that's the first time, I mean, I heard from I've never had a presentation. I've heard from other board members just reasons that people got involved and it stopped it. And I could not understand how we could buy it, spend the money on it, and not have all the T's crossed, I's dotted, and that bothered me. And so I think it was important to say that. And the other thing with planning, it frustrates me, even with the freeze now. We'd have an elementary school in the area where this growth is, and we wouldn't be in this frustrating position. Now, I understand about moving forward, but I think that we learn from history. I think we as a board need to be sure we have legal counsel and, giving us all our options of could we have pursued to have done this then. So I think that there's merit in learning all of what you've presented to us tonight, and I appreciate it.
Well, Ms. Hammond, just if I may, and probably put my foot in my mouth by saying too much, if I had any criticism of the way this transaction was handled, I would suggest to you that probably the district was too focused on doing this all internally. This process seems to have been driven by the superintendent at that time, the chief financial officer, and the director of the new acquisitions. And so, surprising to me, having been on another school board at that time, that district officials were going out meeting with people to negotiate contracts for purchase of property. So if you were to ask me, do I have any criticism that I can look at retrospectively as to how you may have gotten in that situation? In one case you may say that you were too conservative and you were trying to do things in-house that maybe you'd have been better engaging other people to assist you with. But again, that's hindsight, and you could have had other people doing it, could end up just the same. I can't predict what would have happened, but that's just my professional observation that, as we deal with these situations, if you don't have people employed who are experts, who are specialists, who have specialized knowledge in those areas, sometimes it helps to have that assistance to avoid things that are unforeseeable, because unforeseeable things happen.
I know you were at the meeting when I tried one last-ditch effort to reclaim building on this land instead of the other site. I lost, but at least I have an understanding of how all this happened, but it is frustrating.
Yes, ma'am.
Mr. White.
Can you move forward to the slide that had the actual vote, I think, for this motion right here? And you can see I made that motion, so I was on the board at the time, and I mentioned a man, Mr. Tom Crooks. Did you ever find Mr. Crooks?
I'm told that there is a Tom Crooks in Newberry County. I'm not sure if it's the same Tom Crooks, but I have not found that person, haven't found somebody who knows that person.
And I can say I was there, and I do have some recollection. And I don't think it's as one-dimensional as, it might have been better if we got an outside people. That, the superintendent and everything was going on. That's the way it was being done. I can tell you I made this motion because there was a legitimate claim for tortious interference with this contract. This gentleman appeared at Dr. Hefner's office. Dr. Hefner was fairly new, and I'll never forget this because Dr. Hefner said, this gentleman appeared in my office, and I thought he was going to have a heart attack sitting on the other side of my desk. He was so angry, and he was so mad, and it had to do with this property, and something about a school board member going in there and stirring these families up, and all this transpired shortly after that. And I'm not going to mention the name of the school board member because we couldn't find this person, so we can validate what I'm saying to you, and Dr. Hefner's no longer here, but I'm going to tell you there was another fact here. We had somebody on this board that was accused by this gentleman of interfering with this contract. I didn't make this motion for nothing. I'm not making this motion up. It's, 7 years old, and it was passed. Ms. Hammond, I believe you supported that motion. So to say it's all responsibility of administrators not doing a job good enough, it was also a responsibility of somebody sitting on this board directly interfering with the process. And my recollection is the committee never got seated because it would have been so unpalatable for us to be suing a member of the community over a breach of contract when you got somebody else sitting on the board that's out there churning stuff up that's in opposition to what we're doing and saying on this board. And one of the biggest lessons that we can all take from this is You're supposed to follow the will of the majority, and when the majority votes to do something, you're supposed to implement it and not be out there in the community assaulting it and attacking what this board decided. That's a major lesson from this whole thing. The second thing is, I think you mentioned the condemnation. That was used politically to say, look at the district out condemning land. The shortcut version of what you said was the seller asked us to do it to expedite clearing title, and it would have facilitated us. We didn't have to do it, but that condemnation thing was misused. We don't go out and condemn land. And I think the third thing, my recollection, and I'm not sure, Mr. Gann, if this is totally correct, and you may have a better recollection, there was a decision made by the superintendent at the time to abandon the site and spend the money, because we were at the time promising the community, because of criticisms about the decline in enrollment that occurred with the economy crashing. It took years for it to come back, and it wasn't clear where things were going and how they were going. I think it was appropriate, based on enrollment trends, that money was better spent in the other schools, and we could come back and do a school later. And as it turned out, the trends were such that the need, by the superintendent here at the time, it was more appropriate to put the school at Amix Ferry Road. So if we were to say today, can you build a school there, you might be able to, but it's a better site where it is today. And that's why the decision and the majority of this board voted. So rather than going back in time and having board members try to assault what we're doing today, the lesson to be followed is follow the will of the majority and implement the school that we're trying to build. In fact, that is the fastest path to relieve the overcrowding in the elementary school systems in Chapin, is build the school on Amix Ferry Road. And we don't need any more debacles that are evidenced by this
Gant,
motion
this
in the
doesn't have
minutes.
anything to do with this conversation.
I think it has
Actually,
everything
No,
to
it
do with
doesn't.
it.
It does not.
Mr. White, Mr. Lovelace, it has everything to do with it.
No, it doesn't.
Yes,
We're talking about.
Mr. White, Mr. Lovelace, you don't have the floor. I'll call you out of order. Mr. White, will you wrap up your comments, and then we can come back
I
to you,
think
Mr.
I was
Lovelace?
at the end, but I think my point's made that motion was made 7 years ago based on the facts in existence then. And the biggest takeaway is the board should follow the majority when the majority votes, and the majority has voted to build at Amix Ferry. It voted to build at this site, but there was interference, and we think it might have been a board member, but we know there was outside interference in that contract.
Thank you. We'll go to
That
Mr.
is-
Cates.
The information, like I say, is referenced by that motion and by some other colloquial things, is that there was something happened that caused people to change their minds. And I guess the one thing I'll say is I've tried to make sure at Dr. Melton's behest that if I can't document something in the paperwork, I'm not saying it. And so, because I want to give y'all what I can glean from the facts. And obviously, y'all have some memories and some recollections, as Mr. Hammond, or Ms. Hammond and Mr. White have shared this evening about some of the things that happened at that time.
Mr. Cates, and then we'll come to Ms. Hammond.
Mr. Montgomery, I was not on the board at this time, so I wasn't privileged to the process. However, I was privileged to the process at Amix Ferry, where we used an outside consultant to guide the district. And it appears that process was less problematic compared to this, where we used someone who that was their expertise, was in school site selection. So while you didn't, I don't want to denigrate the work of a previous board or administration, but I do think hopefully we learn from that process and we use the folks that have the expertise to provide wise counsel and guidance to the district. My other comment would be that once these documents are a few corrections, my understanding is they'll be made public
That is
as
that is
part
my
of the
understanding, yes.
board packet that appears on the district website. I just wanted the community to know that this presentation will be made available as all our board packet information is normally made available.
And Mr. Cate, I do want to make sure that, my purpose in responding to that question was not to be critical of what had occurred, but to the question I was asked, is there better practice? And that was what I was trying to address. And again, we have to recognize that this occurred almost 9 years ago. This was concluded 8 years ago, and not only has the environment changed, but what I would say is better practices probably changed in that period of time to some degree as well.
Ms. Hammond?
I appreciate the opportunity to answer, Mr. White. Number one, I want to make it clear when you say a board member, it's not a board member that's sitting here, because I supported a school on that site. And the other thing, if you had come to our boardmanship, you might have a better tone when you speak to us.
Ms. Hammond, thank you. Any other questions pertaining to the presentation? Mr. Montgomery, Ms. Hutchison?
This is excellent, Mr. Montgomery, pulling this ancient history together. Two things I wanted to speak on. Let me write myself a note. I know it's kind of hard to see this for the public, and so what we have on the screen here, just to be clear, is the motion that Mr. White made, and I seconded about trying to figure out what happened, the misrepresentation that Mr. Crooks reported to Dr. Hefner. And I do remember hearing Dr. Hefner talk about this, and you probably can't see it for the audience. The board members who were for this were Baumgardner, Gant, Hammond, Turner, Watson, me, and White. And the one board member who was not for that, who abstained, was Murphy. Just in case y'all can't see that. I know it's difficult to see. The second thing is, as we talk about this, and I think, okay, I remember this. And one of the things that Mr. White brought up, and I do remember this pretty vividly, is that each year we would have a report by McKibben, demographer, and who would come in and give us a long-term projection of our enrollment. And it was after 2008, 2009, and it looked pretty flat as far as, he was not projecting a lot of enrollment for our schools. So we didn't see the, kind of the boom that we've had in the past several years. That was not part of the projections. And I do remember that in Dr. Hefner's, I think it was Vision 2015, 14, I'm not sure what the first one was, that at that point, that's when he recommended, based on the fact that of the more level, that there wasn't a lot of growth, we weren't declining so much, but it was just kind of even, that we should use those funds, and that the elementary school did not look at that point that was as urgent as making some of the improvements to Irmo High School and to Dutch Fork High School. And so the board did approve moving forward with those recommendations by the superintendent. So that's just my memory coming back.
Mr. Montgomery, I was going to ask you, and I don't want to put you on the spot with this, but you've covered this, but run back through our options again, and would you pull your microphone up just a little bit? I've had a little bit of trouble hearing you.
Mr. Gant, I can't say that anyone has ever complained about not being able to hear me, so that I appreciate that. I'm glad to learn that I've become softer spoken. The options that I put up here are just that you can look at this as a school site. If you do that, you're going to have to plan according to the situation and the issues that we now know about. You're going to have some options to do that, the way you plan, the way you design, whether you acquire or swap or otherwise get some additional frontage. You can also look at rezoning. You can also look at getting a variance or applying to get that requirement waived, either through an appeal of a staff decision. And one of the other things you're dealing with is a different staff now than there was 10 years ago. They might come to a different conclusion, or you might be able to deal with different issues. Again, the other option is, as I said, I think that at least from my layman's look at the property prices out there, you made a good buy, and you could realize a benefit to the district if you didn't want that site and you wanted to market it and sell it. Obviously, there is a legal process that you have to go through as a school district both to get permission of the Department of Education and other things in order to sell property. It's not so easy as just wanting to sell it, but it's certainly a decision if the board wanted to make and the administration wanted to recommend that you could start a process and you could probably justify, depending on what you dealt with. You know, and one of the things that's going to help you, and I know it's imminent, is learning what your long-term facilities plan recommends. And you may have some recommendations for the use of that site in that plan, or you may have some recommendations for doing other things. But I do, you know, and I think everyone realizes it, but just remind you that a lot of times folks think that selling a piece of school district property is just a wham bam, we list it, we sell it, we close it, and it is a legal process that requires a little more than that. So just have to be mindful of that as we look at those options.
Any other questions at this time? Mr. Montgomery, we really appreciate the recap to bring us up to speed. We've had that request for a while, Ms. Hammond. I hope that
Thank you. Yes,
satisfies
I've
your-
been asking for it
and
for 2
all.
years.
Well, thank you. It was a history lesson for me as well.
Thank you very much.
Thank you a lot.
Thank you. Thank you.
That brings us to item number 22, which is proposed new board policy, KLGA, school resource officer, shown in Exhibit J. Dr. Harris.
Thank you, Mr. Chairman, members of the board. Oftentimes,
Dr. Harris, can you pull that?
certainly. Oftentimes, school districts are in a position of catching up with policy, but in this particular case, I think policy is catching up with the school district here in District 5. This is a new policy that we're sharing with you on tonight that speaks to the use, the significance, and value of having school resource officers in our schools throughout our district. That comes from the conversations and meetings that the legislature had with our State Board of Education when we talked about student discipline. It was coupled with the use of school resource officers in schools. So this particular policy offers a definition. It talks about its jurisdiction of a school resource officer, which is statewide, and they are able to, obviously, to travel with our schools throughout the state and various athletic or other events that might occur. It speaks to the fact that school resource officers are not disciplinarians. That is the role of the administration, and that their use and their function is in reference to criminal activities, as well as providing and assisting with immediate safety risk and providing a safe learning environment. There are roles and responsibilities that are delineated throughout this particular policy, and it also ensures that the school resource officer assists school staff and school administrators with emergency crisis planning as well as building security matters. All of this is outlined through a memorandum of agreement that is an annual process that is reviewed and signed and supported by, in this particular case, both the school district as well as both Lexington and Richland counties. We're very, very fortunate for a number of years that your support and approval years back to have currently 26 school resource officers assisting our schools here in School District 5. Thank you.
So we'll open up for questions now. Ms. Hammond?
I have do we have, in the largest schools, do we have two, like at the high schools? Is that
In
correct?
our high schools,
In
we
our-
have-
in District 5. And then I know Governor McMaster's initiative, and I think it will probably get support, is a lot of the poorer school districts that don't have any. He would like to see it, one in every school. Do you think that that initiative, it really just won't affect us? We'll still have I think Dr. Melton looked it up for us, Richland County's 50, we pay 50%, they pay 50%, and then 75% with Lexington, we pay. Do you think that funding would change anything we're doing, where they would give us some money?
We're monitoring that, and I think this is one time I would say that Mr. Richardson and his work with legislators in recent days may have more insight on that. I'm not so sure that we are already in the position of having school resource officers that we will have the greatest benefit, but that's one that we're going to continue to watch and continue to monitor to kind of see where that goes and see what impact it might have for School District 5.
I had one more, Mr. Gant. May I ask it? Ever since, and since I'm a teacher and I'm in a school with a resource officer, they have such an awesome responsibility, and they're so important in so many ways. But ever since the episode, I think it was Spring Valley, in some ways, and we had a presentation at one of the school board meetings kind of soon after that, which really, to me, hamstrung a lot, that they came out with a whole new policies about what they can and can't do. And so I was wondering, within our schools, is it left to Sheriff Kuhn or to Leon Lott to do that training for them as to what they can and can't do? I mean, I know we can see our policy, but I'm just thinking about the actual SRO officer on the job. If we, in our schools, through our district, sort of have meetings where maybe the SROs meet together about what their roles and responsibilities are, because it really did, at least ours, and I talked to him, it was almost like he just decided to hide away in some ways, afraid that they were going to overstep. Only if it's breaking the law do we have any jurisdiction in your school. But I still think in training, there's so many more things they can do that's not doing the discipline for a teacher. So I wanted to see if we do training, for hours, just sort of on the side of what we expect in our schools.
Let me share three perspectives of that. One, all school resource officers have to be trained in order to be a school resource officer by the South Carolina Criminal Justice Academy, and there is a specific certification, very different from what I would call a road patrol that resource officer has to complete. So they have training there at the beginning. Then yes, the various counties do provide training in reference to the school resource officer role. And I think the third part that I share with you is that we, with the benefit of our safety team that we have now, we continue to work with and doing an outstanding job. They are also meeting with the various counties in a training center over at Dutchbrook High School where they're housed, making certain that we are in constant communication, talking about things that are specific to our schools here in District 5. So they are an integral part, resource officers, an integral part of the things that we do as it relates to emergencies, crises, safety planning, audits of that nature. So I think it's a threefold perspective from the Criminal Justice Academy, what the various counties and sheriff departments do, in addition to what we're trying to do here in School District 5.
Mr. Cates.
Dr. Harris, you were asked a question, but I don't know if you were given a chance to answer about the number of resource officers in the high school versus our other schools. I just wanted to come back to that.
Thank you. Yes, in our high schools, all of our high schools, we do have two resource officers that and by design, both counties are supportive of that, and we are certainly in agreement as well that high schools, being larger entities, would require and certainly demand a additional presence of a law enforcement officer. So we do have them both, two in our high schools, yes.
And then at least one at every other.
And then one in all of our other schools, that's correct.
And that, to me, would indicate that at District 5, we're leading the way in that model, and that's well beyond what we hear from the rest of the state. And I appreciate previous board and this board's commitment to safety and security of our students. I'm always amazed. I thought it was telling last month when the resource officer was so highly spoken of and what an impact they were making, and it kind of humanizes law enforcement, and I think that's a great opportunity, and I just wanted to thank you for continuing to lead us as we lead the rest of the state in that area.
Thank you.
All right, Ms. Gardner.
Thank you. I just want to echo what everybody said about how much we appreciate our current SRO officers and the ones that we know. We have a great staff here. But for clarity on the policy, under jurisdiction, there's some wording here that I would hope that we would clarify because of the media and the stuff that we've been seeing about, what is acceptable from an officer and what isn't. And it says here that school administration staff will have the primary responsibility for maintaining proper order in the schools and for disciplining students for violations of board policies and school rules. And then it says a school resource officer is not a school disciplinarian. I would hope that we could clear that. To me, that sends a mixed message. And so I know just because you discipline doesn't make you a disciplinarian, but it tends to go hand in hand. So should we have some clarity on that word for disciplining students shouldn't be there because that's not one of their roles unless it is, and then they are a disciplinarian. So that's just a thought that I had. I don't expect you to answer that, but just maybe look into to changing the wording. I don't know enough about it to know how to change it, but if I think of a good idea, I'll mention it later. But I was concerned about that specifically. And the memorandum of understanding, is there a way that we could see a copy of that? I'm sure that they all have a copy themselves and they are at the schools, but as a board member, I don't know how to find access to that, so.
We do have it available.
Okay.
Certainly, if that's something you like, we can certainly make that available to the board members, absolutely.
Okay, thank you.
If I can say this too about the discipline, I think it might go a little bit to what Ms. Hammond was asking. That's a point in which the counties, and when I spoke of the legislatures and the State Board of Education, really honed in on in reference to ensuring and making sure that we're clear across our state that school resource officers don't discipline our students. And so I think that language is probably there for that purpose, trying to really make certain that when it comes to the discipline of students, that school resource officers yield to the administrators to make certain that they are the ones who are handling that part of it. So I think that's what was trying to be communicated here. I'll certainly look at it again to see if there's a way we can try to simplify it perhaps and make it a little clearer.
Yeah, because if you just take out like the "and," it just says school administrators and staff have, it's just like, I get it. I like that it says that, but maybe that's what's included in the MOU, though. I guess that's where I'm going at. I didn't, the understanding part, memorandum of understanding, is it more listed about what's expected of them and not disciplining? And
There is language about absolutely.
maybe that's where I'm missing okay.
Okay,
So if I read that, maybe I'd feel better about that. Okay.
okay.
Ms. Hammond and Mr. Cates.
This just goes to Ms. Garner. This might help a little bit in the answer he was explaining. In a real-life situation, let's say 2 kids are fighting in your room. It is my job as the teacher to call the administrator, and they stop the fight, not the SRO officer. So, I mean, there are a lot of parents that really don't understand that, whereas there have been times the SRO officer, you think about the fight, so it's really bad, so you want them to come. But it has to be that the administration has investigated it first. That's the way this new legislature is saying. So I really feel for our SRO officers in the sense of being there to really help you. Because sometimes 2 guys are really big and a fight turns into 3 or 4 people, and one little teacher or one administrator, it's hard. You need the officer. But there is a protocol of it. And if you break it, then you are breaking the law. So that may be why that wording is like that.
Mr. Cates.
I yield, Mr. King.
You. Just a little point of clarity. I just wanted to thank our board, and actually a board about 5 years or so ago, when we took that step to commit, without having funding from any source, to have SROs in all our schools. And I can personally tell you, and I think, but almost guess every board member at this table will tell you, I haven't had one complaint about spending that money for those SROs. And I've had a lot of folks just say, I'm really, really glad. I feel better. And we all know there's not a lot you can do about craziness sometimes, but you can take steps to try to prevent those things from happening. We took that step at a time that we also put in, I believe, the pre-K program, same time frame. Hadn't heard any complaints about that either. So I just want to, my hat's off to every enforcement officer in this room. Thank you for what you do. And obviously, Dr. Harris, you're going to see our SROs more than we do, but we appreciate what they do in schools. Absolutely. To see that car sitting at a school, knowing an officer's there, around the halls, in the office, makes a lot of difference. Absolutely. And the students are not always the problem. We always know, as adults, sometimes we're the problem. So it's just an extra piece of safety that I think this community expects. And it hadn't been a problem, and it's unfortunate that we, in this day and time, I have to even think about that. But my hat's off to you and your staff. Please convey that to our SROs throughout the district, and we will as much as we can.
So, thank you.
Any other questions or comments related to this SRO, school resource officer policy? All right, seeing none, that takes us to our last item, and I would like to thank everybody that, I thanked you early for coming, and I thank you, Mr. Salva, I see your staff is still here long into the wee hours, and a lot of other folks, so we thank everybody for coming tonight. I will tell you that the reason that staff is here, as soon as we adjourn, they're going to set this room up for breakfast in the morning, so I know what's going to happen. So I'd ask everybody to expeditiously, we need to exit this room, and so they can get that done, and they can get home, because those kids will be here, maybe 7:15, 7:20 in the morning, eating breakfast. So we do thank you. With that, I'd entertain a motion to adjourn. Do I have a motion? Ms. Hutchison.
I move that we adjourn.
We have a second. Mr. Cates seconds. Any discussion? Seeing none. All those in favor, raise your hands. And we thank you all very much for your input tonight. We're adjourned.